Great. Welcome to our Y.E.S event. Today we have with us Matt Margolis. He will be discussing Medicaid and how to protect your assets in a legal way. And there are a lot of nuances and information to know about this topic. And we're so happy to have you here. And yeah, with that being said, we thank you on behalf of the North Suburban YMCA, and we'll let you take it away, Matt.
Sounds good. Thanks, Amy. So, good morning, everybody. As Amy mentioned, my name is Matt Margolis. I've got an estate planning practice in downtown Park Ridge. I am, however, a Northbrook resident and frequent the Y with my kids who both take classes there. And yeah, I've been doing these talks now with the Y for about 8 years, I think, maybe 9 years. The goal is just really to provide some education and hopefully have people learn a little bit of something, a little something that they didn't know prior. We do. I think I do about 6 or 7 of these over the course of the year. I used to do them every month. So a little bit of background on me. So as I said, I've got an estate planning practice in Park Ridge. With sort of like a side niche of elder law where, we help people. So on the estate planning side, we do wills and trusts and powers of attorneys and work with folks that are, we do powers of attorney we work with 18-year-olds going out to college, putting powers of attorney in place all the way up to, working with individuals in their 90s or triple digits who really might not have elder law needs in necessarily. It might just be, making sure that their estate planning is up to date, making sure that they've got good powers of attorney documents. I always love when somebody comes to me and they are of a certain age and they say, I feel like it's time that I need an elder law attorney. And most of the time it's really just that they need some estate planning. So, and then on the elder law side, what we sort of work with is helping people. We help people apply for Medicaid, but we also help people do some pre-planning. So there's folks that we meet with where they want to do some asset protection. We'll talk a little bit about that today, where we can help protect some assets, sort of to avoid a situation where they need long-term care down the road and they're able to maybe protect some of their assets and not use all of them on their care. So I'm going to sort of discuss, I'm going to discuss a few different things during the talk today. I'm definitely open to people asking questions. If you're able to type the questions in the chat box, if that's something you're hip to, that would be great. Otherwise, if you do have a question, then it would be easy for you just to show your screen and kind of raise your hand. I think there might be like a way that you can kind of like raise your hand without showing your screen. I think there's an option like that. And so feel free to do that as well. Again, I'm happy to answer any questions you have. I really prefer, though, the only thing about the questions is I really prefer that they're not extremely personal. Even though we don't have tons of people in the meeting today, there's a time and place for those personal questions, and I really prefer to keep the questions, at least for these talks, to be a little bit more broad. Asking me to maybe clarify something or even asking me to explain something that you might think I should be covering and I'm not. Anything very specific to you or a family member, I would just ask that maybe we save that for another time. I will just dive in. The goal of the talk today is to provide some information on asset protection planning and Medicaid and how that works. But I'm really going to start, and I start a lot of my talks with this because of how important I think it is. We're really going to start talking just a few minutes on powers of attorney. So, I think power of attorney documents for the 3 people on here, plus Amy, if you're not familiar with them, in Illinois, we have 2 types of power of attorney documents. We have a healthcare power of attorney and a property power of attorney. And these are documents that we're putting in place so that in a situation where I'm incapacitated and I'm not able to make my own decisions, I've now named somebody that can step in and make those decisions for me. Okay. And so the healthcare power of attorney is where I'm naming somebody to make medical decisions, right? Who can step in and make medical decisions for me in the event that I cannot make my own. I can name as many people as I want to on the healthcare power of attorney, but I'm naming them one at a time in succession. Okay. I'm not naming them. I can name people together. Okay. Clients always ask me, can I name my two kids together? We can't. Illinois doesn't allow that. There are some states that do allow that. I'm actually glad that Illinois doesn't allow it. You know, think about a scenario where a serious medical decision has to be made, and you've got two people named, and even though they both had a conversation, and let's say it's me naming two people, right? Let's say I had a conversation with these two people at one point, and they both know what I would have wanted them to do in this scenario, but one of them is forgetting, right? Or one of them is maybe not forgetting, but one of them is saying, yeah, I know that Matt said that, but I don't know if he would have wanted actually if he would have actually meant that in this scenario. I mean, if I had two people named and they couldn't agree, it would be a pretty difficult situation for me to be in, especially if there's maybe a decision that has to be made sooner than later. So, um, again, Illinois, healthcare power of attorney, I can name as many people as I want, okay, but they're one at a time in succession. We really want to make sure that we're naming the right people, okay? You know, we should be talking to the people that we're naming as our healthcare power of attorney. You know, while we might think that somebody is comfortable stepping in to make a medical decision for us, or we think like, oh, this person's perfect because of this or that background that they have, we might talk to them and realize that they're not comfortable making a decision, you know, for us. We might realize that, yeah, you know, this person has a medical background. They seem like they'd be great, but you know, it's my daughter, and I've told her that I don't want my life artificially prolonged. You know, I don't want to be connected to life support. I don't want extreme measures taken if I'm going to have no quality of life. She might tell me, Dad, I'm not able to do that. Right? I won't be able to do that for you. Okay. So good to know, again, good to know these things, right? Um, so again, we can name as many people as we want, but they are named one at a time in succession. There's a question in the chat box: under what circumstances is the successor utilized over the first person listed? So it can kind of vary on the type of power of attorney that it is. And so before I answer that, let me discuss the property power of attorney, and then I'll answer that question. It's a good question. Within the healthcare power of attorney, we also get to make decisions. We get to decide when the power of attorney takes effect. You know, does it take effect only upon incapacity? Does it take effect immediately? You know, do I want this person that I'm naming first to be able to sort of step in and be making decisions with sort of alongside me with the doctors? And then on the other aspect of the power of attorney, I'm deciding, you know, how do I feel about end of life care? Sort of what I just talked about. Do I want my life artificially prolonged? Or, you know, sort of the two options are keep me alive no matter what. I don't care how terrible things are looking. I don't care what my chances of having any kind of quality of life are. I just want to be kept alive. That's one option. The other option is really the quality of life, right? Do what you can to keep me comfortable. I'm not saying don't try, but I really don't want any extreme measures used to keep me alive. Okay, if it's my time, it's my time. If I'm not going to have any kind of quality of life, let me go. Again, you know, I think what's unrealistic is that we're going to be able to share with the people that we name on our powers of attorney every single situation that might arise and what we want them to do in those situations, right? That's just it's not practical. It's by any means. And if anybody's a Seinfeld fan, there's a great Seinfeld episode. You can look it up, and it's Kramer sitting down with his attorney and the attorney and Elaine, his friend Elaine, and he's basically thinking of naming Elaine as his power of attorney. And the attorney's going through all these various scenarios that Kramer might find himself in from a healthcare standpoint, and whether Kramer would want to be kept alive or not. And so actually, I mean, for me especially, right, because it speaks to what I do, and obviously it grossly humorizes it, but it's hilarious because it's of how unrealistic it is, right? There's just no way. And so to me, what's just so important is when you are naming somebody as a power of attorney, you need to talk to them. You need to let them know how you feel. It doesn't need to be a long conversation. I'm not saying you need to spend 5 minutes or 10 minutes, but I can only imagine that if I had to make a decision for somebody from a healthcare standpoint, it would be so much easier for me to do that if that person actually shared with me from their mouth, hey, listen, I'm naming you, here's how I feel, versus me having to step in and make a decision and I'm simply looking at what box they checked on the document. Okay. The other power of attorney we have in Illinois is a property power of attorney. So the property power of attorney, it's not just dealing with property. So many clients ask that. Makes sense based on the name. Bless you. And so the property power of attorney is really more we kind of look at it as the financial power of attorney, right? Who can step in to make all those decisions for me that are not healthcare in nature? Okay. So this could be who can have access to my checking accounts, my savings accounts, my IRAs, my 401ks, who can deal with my house or any real estate I own, who can sign a contract on my behalf, who can deal with issues that might arise with Medicare or Medicaid or Social Security, who can sign my tax returns. My property power of attorney is being given, a lot of power, a lot of broad power to manage things for me. Obviously, it's important that I'm naming people that I trust. Okay. Similar to the healthcare power of attorney, I can name as many people as I want, but they're being named one at a time in a specific order. You cannot name them together. Okay. You cannot name co-agents. Okay. The person that you name on a power of attorney is called your agent. You cannot name co-agents. Again, we want to make sure we're naming the right person for the job. I mean, in so many cases, I meet with clients, I meet with folks, and they have this, it's like they've got 3 kids. They're going to, in so many cases, they name their kids one at a time, oldest to youngest. And in every single situation, I will ask my clients, are you just naming them because of their ages, or is this actually the right order to name them? And sometimes I get the response that it's the right order. Okay. And actually a lot of times. But there are times when I get the response that says, well, I don't want my older one, actually my younger one would probably be the best, but I don't want my older one to feel bad because I named our younger child over him or her. And my response in these situations is that you have to be selfish when you're doing this planning. It's not to be mean. It's not mean-spirited to pick somebody who you think is the best person for the job. When we're talking about somebody stepping in to make medical decisions for us or financial decisions, it's got to be the right person. We can't be concerned about hurting somebody's feelings. And frankly, I tell all my clients, do you want me to talk to your son or your daughter that's being named last? Because frankly, I'd rather be in that position for my parents. Stepping in as a power of attorney is not a gift. Now, there are some adult children that come in with their parents, my clients, and like they want it. They want that role. And there's like maybe this feeling of like control, or they want to protect their parents. And most of the time I believe it's coming from a good place. But sometimes it's just, I feel like they want this control. And then they are typically the first person to then complain to me down the road when all of a sudden they're spending all this time as power of attorney, handling all these things, juggling all their parents' affairs. And now they're complaining about the time being spent, right? And all I can think of is the meeting that we had when that son or daughter was like, no, I want to be your power of attorney. So I tell my clients, I'm like, I'll call your child and let them know that, being named last is, is fine. They won't have to do or step in and handle all these things, which they might have to. So when we talk about, when a successor would come in. So if I've got 3 or 4 people listed, right? When would that second person listed come in and maybe step in versus the person that's listed before them? It's really going to depend on the power of attorney to some extent. So here's what I mean. Technically, let's say for the property power of attorney, it's going to be very black and white. For the property power of attorney, let's say I name Amy first, and then I name Bob after Amy. So let's say, Bob, who is the successor to Amy, wants to step in. Okay, I'll just use the example. He wants to step in. Well, the only situation that he's going to be able to step in and kind of go over Amy is Amy either has to resign. Okay, so she has to put something in writing resigning. She has to be incapacitated, which would have to be documented by a letter from a doctor saying that she does not have capacity to manage her own financial affairs, which would mean that she does not have capacity to be somebody's power of attorney. Or 3, there would have to be a death certificate. All right, so she's either going to be deceased, incapacitated, or she has to resign for that person after her to step in for the property power of attorney, okay, for the financial power of attorney. Now, of course, the person that drafted the power of attorney could always draft a new one, right? So if I still have capacity, if it's my power of attorney, right, in this example, if I still have capacity to sign a new power of attorney, and maybe we've discussed as a family, like, yeah, I named Amy first, but it's 3 years from the time I drafted the document. Amy's got a lot of stuff going on in her life. If somebody really needed to step in and kind of help me out, Amy wouldn't be the best person at this point. And so rather than knowing that when we get to that point, Amy's gonna have to like sign some resignation, we might just say, maybe it makes sense to just sign a new power of attorney today. So that Amy's still on there, but maybe she's now a backup to Bob, right? Because if Amy resigns, also she's done. She can't get back in. Okay. For the healthcare power of attorney, I say it's different because for medical decisions, what I've seen in the past, I mean, technically you could argue that it should work the same way. That, if I name Amy, then Bob for my medical decisions, Bob's only gonna be able to step in if Amy resigns, is incapacitated, or deceased. But for medical decisions, sometimes it's a little different. And a lot of hospitals and medical institutions will, it's like if they can't get a hold of Amy, if a decision has to be made and they can't get a hold of that first power of attorney that's listed, they might very well go down to the next person that's listed on the power of attorney without needing any kind of like resignation or incapacity, letter of incapacity or death certificate or anything like that. Because if they're, they will kind of look at the situation and say, listen, we need somebody to make a decision now. Matt named so-and-so after Amy. And so if Amy's unavailable, we are going to go look to the next person. And so again, that's why I say they're a great question and they are a little bit different, just kind of in practice. I mean, I will also say that I've seen situations, when it comes to the property power of attorney, there's no bank or any place out there, any financial institution that's just going to like take Amy's word. If she goes into the bank and says, oh, I'm Matt's power of attorney, I need to write a check to pay a bill for $500 or whatever. There's no way they're going to work with Amy as my power of attorney without Amy showing them a copy of the power of attorney. They will then look at the power of attorney to see, is it effective or not? Okay, so in a lot of cases, my clients will have the property power of attorney take effect immediately. And that's because they trust the person they're naming and they want it to be more convenient. So maybe they're not incapacitated, but it might be more convenient, especially for some of my older clients. Maybe it's more convenient for their son or daughter who's power of attorney to be able to write a check or help pay bills or help with their tax returns or things of that nature. But the financial institution is going to be very, very conservative, very much looking at the power of attorney, whether it's effective, et cetera. With the healthcare power of attorney, I mean, I've had clients tell me that they were in the hospital, their mom was in the hospital, and literally the nurse just asked, who's the healthcare power of attorney? Didn't even ask to like see a copy of it. Okay. A spouse does not automatically become a power of attorney if for their spouse. An individual does not automatically become power of attorney for their spouse if the spouse becomes incapacitated. Power of attorney is a legal document that you have to sign. Now, there is something in Illinois for medical decisions. Now, before I get into that, the whole point of a power of attorney is to avoid a guardianship, just so we're clear. Okay, we put powers of attorney in place because we are now legally naming somebody that can step in to make decisions for us in a situation where we can't. If we don't have powers of attorney and we're over the age of 18 and we become incapacitated, then somebody close to us is going to have to hire a lawyer, petition a court, go to court, and have a judge appoint that person as a guardian. Okay. So believe me, powers of attorney to me, some of the most important documents. Okay, we want to avoid that guardianship process. There is a default in Illinois for healthcare decisions. There's something called the Healthcare Surrogate Act. Okay, I won't go into it in detail, but the Healthcare Surrogate Act really provides sort of like a backup for not having a healthcare power of attorney. Okay, there's nothing that exists like that for the property power of attorney. Okay, so if somebody's incapacitated and they don't have a property power of attorney and they're over the age of 18, somebody will have to petition a court to be their guardian. Okay, no way around that one. But for healthcare decisions, there is something called the Healthcare Surrogate Act. You can look it up. There's tons of information online. And Illinois kind of lists, if I'm incapacitated and I don't have a power of attorney, these people in this order kind of that are close to me would be able to step in and be my surrogate, my decision-making surrogate. And I believe the first person on that list is a spouse. Okay, I just haven't looked at that. I haven't looked at it in a long time, so I don't want you to quote me on that. But if you look it up, it kind of lists out who would step in by default to be your healthcare decision maker. And it's good. It's good that we have that because we want a situation where, if God forbid, a serious medical decision has to be made, somebody doesn't have a power of attorney in place, we have this backup. Okay. But it makes sense that there's no default for financial because there's a lot more things at play there with somebody all of a sudden having access to somebody's financial decision or financial assets. All right. I don't want to go into powers of attorney anymore, but I always like to kind of start with that. I think it's really important. So let's talk about, I think there's a lot of, there can be a lot of confusion with Medicare and Medicaid. And listen, we are not Medicare specialists by any means. At this point in my practice, even when it comes to Medicaid, I can speak about it. I know enough to give this presentation, but even a lot of the Medicaid things, my partner is really the one that handles those here at this point. But Medicare, again, we don't deal with Medicare. Medicare there are professionals out there that concentrate in that, typically not attorneys, normally like benefit specialists, but Medicare is insurance. Okay, Medicare is for the most part going to be insurance for somebody that's over the age of 65 or under the age of 65 but disabled. So most people that are, if they're defined as disabled by the Social Security Administration and they're receiving SSDI, typically you're on Medicare in those situations where you're not over the age of 65. But what we're really talking about today is Medicare in the context of a 65-year-old plus individual. And so Medicare really has a very limited, well, I shouldn't say that. Medicare does not pay for long-term care, to be clear. I will mention here in a second a very limited benefit that Medicare pays for, but it's truly not long-term care. Okay, long-term care is going to be something that we are responsible to pay either out of pocket or it will be covered through Medicaid. Okay, if we apply for Medicaid. So one very important thing for people to understand, and this is huge, is that in a lot of cases where somebody goes to the hospital. So I'm not sure if anybody here has ever dealt with a situation where they've had a loved one go to the hospital, maybe for multiple days, and then they're discharged from the hospital and they go typically to a skilled nursing home for rehab. Okay. Now, Medicare in most cases will cover a lot of the rehab. Okay. But only if we meet the 3-day rule is what Medicare calls it. Okay. And what that means is that if I'm in the hospital, in order for Medicare to cover my rehab at the skilled nursing facility when I get discharged from the hospital, I need 3 overnights in the hospital, and I need to be classified as inpatient status. It cannot be observation. Okay. So very important to be an advocate for your parent, your spouse, your uncle, whoever this person is that you are involved in their life and you're helping out. Really important to be an advocate to make sure that they are, because you might have somebody spend 5 nights in the hospital, but 3 of those nights were under observation. People think that because you spend a night overnight, you are automatically going to be considered inpatient, and you're not. Okay. Now here, again, I know enough to be dangerous here, but you really need to make sure you're staying on top of it, because I've had these situations arise where, I had and this hasn't happened for a while, but it was years ago where a client reached out and said, hey, I just got a bill from the rehab facility that my dad's in. And for 1 month, it was like $20,000. Reason being, rehab is not inexpensive. The daily amount that you pay for rehab in a skilled nursing facility could be anywhere from $500 to $800 a day. It's because you're not just there. Some of us might be familiar with, if you have to stay in a nursing home permanently, right? Long-term care. Not a rehab standpoint, just that, the nursing home is now where you're living. And that around this area is probably closer to about $300 a day, give or take, and probably 300 to 400, to be honest. It's probably the range at this point. But for rehab, it could be like $500 to $800 per day. And that's because not only are you sleeping there and they're providing meals and they're providing sort of like the everyday kind of like watchfulness, if you will, that you would get if you were in a nursing home, but you're also doing rehab, right? So you're getting PT, you're getting OT, you might be doing speech therapy, whatever it is. There's all these extra services being provided. Obviously, you're paying more, right? So you got to make sure that when you are not like the day you're leaving the hospital, but you want to make sure, like even after that first night, like, hey, was my mom or dad, are they considered inpatient right now? Are they under observation? I want to know. And if you're finding out that they're under observation, you might want to ask why. I would not just like let it go, because again, pretty serious if they get discharged and they need rehab, and it ends up being out of pocket, which you're not expecting. Okay, so 3 nights, at least 3 nights of inpatient status, right? Of course, they can have eight nights of inpatient status, but at least 3 nights of inpatient status. So if they have 3 nights of inpatient status at a hospital, then they get discharged and they go to rehab. Medicare will cover the first 20 days, 100%. Okay. First 20 days, 100%. Now, after that, from days 21 to 100, Medicare will cover 80%. Okay. This is where things get a little tricky, and it kind of depends on what type of insurance, what type of like Medicare supplement, whether somebody has like a Medicare supplement or a Medicare Advantage plan. I'm more familiar with true Medicare supplement, so I can speak to that. I can kind of give you an idea of how an Advantage plan would work. But if you have an Advantage plan or a loved one has an Advantage plan, I highly urge you to have them look into it and see how it works in this situation. Okay, you want to go into these scenarios eyes wide open. So if I have a true Medicare supplement, then the way it'll work is after Medicare covers those first 20 days at 100%, and then I said days 21 through 100, Medicare covers 80%. That Medicare supplement will kick in and cover the other 20%. So I could potentially not be out of pocket at all for up to 100 days. With a Medicare Advantage plan, they work a little different. And I think that some of them, the way they work, and don't quote me on this, again, you've got to look into your policy. But I feel like the last time I talked to somebody about it, it was, Medicare still covers the first days, 20 days, 100%. And then I think it's like days 21 through 40 or 21 through 50 that Medicare will still cover the 80%, but then you're out of pocket for the additional 20%. And then days like 41 through 100 or 51 through 100, then the Advantage plan will kick in and cover that other 20%. I just know there's a gap. I think with most Advantage plans, there's a gap in there where the Advantage plan does not cover that 20%, and you're out of pocket for it. Advantage plans tend to be less expensive. Okay, so there are pros and cons to Advantage plans and supplement and Medicare supplements. And again, these are just good questions to ask whoever you maybe purchase these plans through, or whoever you worked on it with. And if anybody has any questions, those aren't plans that we sell or we deal with, but if you ever need any help, I've got 2 great resources that I can think of, that I can always send you their information, and you can talk to them to see if your parents or if you have the right plan for you. So really, really important to understand how that works. Now, the other thing here with I said Medicare will cover the first 20 days 100%, and then 21 through 100, they'll cover 80%. The supplement will cover the other 20%. The Advantage plan, again, works a little differently. While we are entitled to up to 100 days of rehab that would be covered, not everybody will get 100 days of rehab. Okay, so for Medicare to pay for rehab, the individual has to be making some sort of progress. Okay, if an individual all of a sudden gives up and they're like, I just can't do it, I can't do this anymore, it's too hard, I don't have the energy, or just physically they can't do it, right? If an individual has plateaued, which is the term that they'll typically use, right? So if somebody has plateaued and they're not able to get, the whole point of rehab is to get somebody better. And so if the rehab facility determines that an individual, even if it's an individual that's trying, but determines that an individual is not really getting better, they are as good as it's going to get. Typically what they'll do is they'll sit down with the family, they'll have a care meeting, and they'll say, listen, in 3 days or in 5 days, Medicare is going to stop paying for rehab. And typically in those scenarios, you have one of 2 choices, right? It's either we feel like we can bring this person home, and maybe they have a spouse that can help care for them, or we're going to get caregivers in place to care for them. we've got some sort of care plan if they come home. And then the other option in most places is a lot of these skilled nursing facilities that are providing this rehab will say, you can stay here, your loved one can stay here, but it's going to be $350 a day. And there's no rehab, right? They're now living there as a long-term resident. So just good to understand how this works and understand that very few situations will you see somebody get 100 days of rehab. Now, sometimes it's just because, hey, listen, they've actually rehabbed really well. And when I say, and even though I don't want to make it seem like when I say they're as good as they're going to get, that's a bad thing. My dad just went through all this. Okay. So I can speak to this, after doing this for 14 years, of course, I knew there'd be a time when, of course, it would hit close to home. My dad just went through this whole process. He was in the hospital for 2 weeks. At the end, like right after Thanksgiving, from there, he went to a rehab facility and he was there for 4 weeks. And now he left and now he's at home, but he's still getting a little bit of, now my mom's, long story, my mom's 17 years younger. So he's got a more spry spouse who can help and help provide the care that he needs, which is limited. It's limited at this point. But so there are situations where somebody kind of graduates from rehab and they can get back home and kind of get back into their routine. But then again, there's situations where that's not the case, right? And so in my dad's case, he did really well, he got better, but he was as good as he's going to get, right? At 92 years old, he's not going to be riding a bike. If he can start using a cane instead of using a walker, that will be a wonderful day. So, it's obviously all about the individual and even where they started. Where were they at before they went to the hospital, before this whole thing happened, right? We definitely can't anticipate in most cases they're going to be better than they were prior to the medical event, but can we get them back to kind of where they were prior, right? So now in these situations where, let's use an example where now somebody is done with rehab and maybe they can't go home. Either, the home isn't, it's not safe for them to be at home, right? Maybe there is no spouse. Maybe their spouse is, just not able to take care of them because of whatever their needs are. I mean, that's very common. Also, sometimes spouses are not the best caregivers. You've got to be really conscious, and a lot of adult children, I think, have to really, really be looking out for their parents in these situations because, in so many cases, you have spouses, and for most of them, and not all of them, but for most of them, they want to care for their husband or wife, right? I mean, they're like, this is what I should do. This is what I signed up for, right? In sickness and in health. But it's tough. It's tough. I mean, again, I'll speak to my example. My mom was helping my dad with things prior to all this happening. But when my dad was at rehab, I mean, the hospital was a different story. That was very chaotic and hectic, and we didn't know what was going on. Once he was in rehab, I almost felt like my mom, there was like a sense of relief. Not that she didn't want my dad to be there, or obviously she didn't want my dad to be there. Obviously, she'd rather have him be at home. But there was definitely an aspect where it was like, she was able to kind of relax a little bit for 4 weeks. My dad was now receiving care from some other people. It really provided some respite for her. I mean, she still visited him every day. Luckily the rehab facility was close by. And one thing I'd always recommend to people is, whether your loved one is in rehab or in a nursing home, the more you visit, the more family visits, the better care your loved one will receive. Okay. A lot of these places are, they could be understaffed. There could be turnover. But at the end of the day, the reality is the more you're there, the more they know a family member is visiting. I hate to say it, but it's true. The better care they're going to take of that person because they know that somebody's there and checking in on them. Whereas, unfortunately, the guy down the hall who has no family members or nobody that comes to visit him ever, I'm not saying they're going to neglect him. Please, that's not what I'm saying at all. But they might be paying a little bit more attention to your loved one because they know you're there every day and they know that if something doesn't seem right, you're going to pick up on it immediately. Okay. So just things to consider. So now we use this example where maybe let's say we have a loved one that they have to stay at the nursing home. Okay. They can't come home. Now they're going to stay there. And now they're responsible to pay whatever that daily rate is. And that's typically how most nursing homes charge. You can obviously look at it as a monthly rate when you take the daily amount, you multiply it by 30 days or whatever. But, for the most part, you're looking at $300 to $400 a day, I would say, on average for most skilled nursing facilities. I'm talking about a skilled nursing facility. I'm not talking about assisted living. I'm not talking about memory care. I'm not talking about independent living. You know, independent living, memory care, assisted living, those are all private pay type places. Those are places where you are going to pay. They don't take Medicaid. Okay, any place that literally is called assisted living, called independent living, and virtually every memory care place. There might be one or two memory care places out there that have that take Medicaid, but 98% of them are private pay. And that means you're going to pay, and the money's either going to come from your bank accounts, or if you're, fortunate enough to have bought a long-term care insurance policy at some point, then your long-term care insurance will hopefully kick in and cover that. But those types of places don't take Medicaid. That's not what we're talking about. So we're not really talking about those today. We're really talking about a skilled nursing facility. Okay. So we can, if we can't afford the $300 to $400 a day, then Medicaid's an option. Okay. And here's sort of how Medicaid works, very, very high level. Okay. We're not going to go into like tons of details, but I think this should be enough to kind of help you guys out if this is an important topic to people. So if I'm applying for Medicaid as a single individual, okay, let's say I'm not married, I'm moving into a nursing home, I'm applying for Medicaid. I'm allowed to have $17,500 of assets. Okay. $17,500 of total assets in the bank. That's checking, savings, IRAs, 401ks, cash value of life insurance policies, annuities, you name it. All of that cannot total more than $17,500. Now, just so you know, that's up from $2,000 and that's what it used to be about 18 months ago. I think about 18 months, a year. Yeah, 18 months to a year. It used to be $2,000. $2,000 was the max. Okay, so now as a single person, I can have $17,500. And as far as like my income, okay, so the amount of income that I can keep. All right, and so income and assets are different. Assets are how much money do I have in all my accounts at the end of the month sitting in the bank account. Okay, look at that as your assets. While your income, that's what's coming in each month, right? And so for most people, it's in these situations, most of the time at this point, they're not working. So we're not talking about any employment income. We're talking about Social Security or a pension in most cases. Okay. And so as far as my income is concerned, I get to keep $30 a month of my income. Okay. So Medicaid, so here's the thing though, if I'm applying for Medicaid, Medicaid covers the bill, right? I mean, stinks, but Medicaid's covering my monthly bill. But so I have to give all my income to the nursing home every month that exceeds $30. Okay. If I have a Medicare supplement or a Medicare Advantage plan, I can continue to pay for those plans. And it makes sense to keep them because it's not costing me anything. Right? Because I'm either giving that additional $250 to Blue Cross Blue Shield or I'm giving it to the nursing home. So we keep the Medicare supplements. And then Medicaid covers the rest. Okay. And then so we have the assets that I can keep, the income that I'm allowed to have, and then there's a look back period. Okay, there's a 5-year look back period. Okay, and that means that when I go to apply for Medicaid, Medicaid can look back and they can ask me, and they're going to ask me for 5 years of all my financials. Checking account statements, IRA statements, you name it. They want to see, basically they're looking to see, did I give any money away? That's what they're looking for. Did I give any money away? And it doesn't matter that, my daughter was going through a divorce and I gave her some money to help her out with her attorney's bills. It doesn't matter that, my son lost his job and I was helping him out. It doesn't matter that I was trying to be a nice grandpa and paying for my granddaughter's horseback riding lessons. Those are all going to be considered gifts, and Medicaid's going to say you gave that money away in order to apply for Medicaid, right? In order to decrease the size of your assets. And it doesn't matter if it was 4.5 years ago or if it was 2 months ago. Okay, that's what they're looking for. But they're also looking to see, did I give anything away for less than fair market value? Okay, what that would mean would be like, did I have a car that was worth $20,000 that I sold to my son for $3,000? Because Medicaid would say I gave away $17,000. right? Did I have a house that was worth $200,000 that I sold to my daughter for 20,000? Right? Medicaid would say I gave it whatever the difference is, I gave that away, but it's a gift. The way that Medicaid treats gifts is they take the amount of the gift, the amount of money that you gave away. And let's just say it's $50,000 in the last 5 years combined. I gave away $50,000. And let's say the monthly cost of care at this nursing home is $10,000 a month, just to make it easy. Medicaid would say, all right, Matt, even though today you have less than $17,500 and you're eligible to apply for Medicaid, you gave away $50,000 over the last 5 years. Well, that's equivalent to 5 months worth of care at this place because it's $10,000 a month. You gave away 50,000, 10,000 a month. The way they look at it is if you didn't give that money away, you would have been able to pay for the next 5 months and then apply for Medicaid. But instead, you're applying for Medicaid today. So we're going to penalize you. And what they're going to do is they're going to say, you're approved for Medicaid, but you've got a 5-month penalty. Basically, you're going to have to figure out a way to pay for the nursing home for the next 5 months, and then Medicaid will kick in. It's a pretty difficult situation if you literally don't have any money. And luckily we don't encounter those that often. But it's not a good place to be in. In some cases, clients are able to get the money back because maybe they did in fact give it away to their kids, right? They thought that they could get away with it, right? They thought they were being smart. They were skirting the system. So in some cases, they can sort of undo the gift and they can get the money back from their kids and then apply. And then they would apply for Medicaid. And they would typically do that before they even apply. Sometimes they would do that, after the penalty, the kids would just pay for the penalty. So again, because of the time that we have, I don't want to go into tons of detail there, but very important to understand that, okay, there are ways to gift assets and ways to protect assets, but you really got to be done the smart way and not just like willy-nilly gifting assets thinking that we're going to be smarter than the state, because they will ask, okay, and they've been getting just more strict and more strict as the years go on. As a married couple, okay, so if we've got a married couple where one individual is moving to the nursing home and applying for Medicaid, let's pretend that I'm going to the nursing home, my wife's at home. All the same things I just talked about for me apply, right? I can have $17,500 in my name. I get to keep $30 a month of my income, okay? My spouse, okay, my wife, she can keep a house, okay? So she can have a house, and I want to say there used to not be an equity limit, but I want to say the equity limit, they just updated it. It's like 700 something thousand of equity. So you can have a house with up to 700, I'd have to look it up, but you can have a house with up to 700,000 plus of equity. Let's see if I have it here. Yeah, I don't, but so you can have a house with up to a significant amount of equity. So the spouse can have a house. Spouse can have up to $135,000 in their name. This number went up as well. This number used to be 109 a couple years ago. So this number has been going up and it's going to continue to rise over the next couple of years. Basically, Illinois was very low when it came to this, and they're starting to kind of creep up to kind of match the federal numbers. So it's technically 135,648. If you want an exact number, but 135,000 to be safe. And then my spouse, so she can have a certain amount of income per month. Okay, she's allowed to have a certain amount of income, and that's $3,948. Okay, so just under $4,000, which is also significant. That number used to be $2,300 and change. So that number has gone up 80%, 75%, which is fantastic. So, and then there's situations where if my spouse has income that is more than 3948, she might, Medicaid can seek to have her contribute some of that, and it's not all of it. It's sort of like there's like a chart, and Medicaid could basically ask her for, I think it's $5 for every $100 that she's over that number, or $5 for every 500. It's something of that nature, but Medicaid barely ever even goes after the spouse for that. Now, one important thing to understand, though, is let's say that my spouse's income is $2,000 a month, nowhere near the 3948. So she got a lot of wiggle room there. But let's say my income is $1,500 a month. If I was single, again, I would only get to keep $30. and pay for my Medicare supplement, and the rest will go to the nursing home. But in this example, if I'm married, I can actually keep my $30, pay for my Medicare supplement, and then I can transfer all that additional income that would have otherwise gone to the nursing home. If I was single, I can transfer that to my spouse to get her up to the 3948. I can't push her over that. But if her income is low enough, I can actually transfer my income to her as long as it's keeping her under the 3948, and we wouldn't have any income that we would have to give the nursing home on a monthly basis. Okay, hope that makes sense. And then the 5-year look back applies to both. Okay, the 5-year look back, it's not that it just applies to me because I'm the one applying for Medicaid. If I'm married, Medicaid's gonna look at all of our assets. And this is a really common question that clients ask. You know, my husband's applying for Medicaid, but we've always kept our, especially in the situations where it's a client, that's somebody that's like, we've always kept our assets separate. We've never really commingled them. Doesn't matter. Doesn't matter. Okay, it doesn't matter that it's a second marriage and that you guys have kept separate assets. Medicaid looks at a married couple as a family unit, and they are going to argue that the spouse is responsible. Now, there are, and I'm going to kind of go through this quickly because of time, but there are a couple things that we can consider here. Okay, so there are a couple exceptions to the gifting rule. Okay, if we have an adult child, and it's a child, not a grandchild, if we have an adult child that's been living in, if I have an adult child that's been living in my home and taking care of me for at least 2 years, up to the point where I move into a nursing home and then apply for Medicaid, I can transfer my house to that child. Now, obviously, this is a situation where I don't have a spouse, because if I have a spouse, the spouse gets to keep the house. And there's nothing wrong with that. So, but this would be a situation where I don't have a spouse. My adult child has been living in the home and caring for me for at least the last 2 years. And I've got to provide certain documentation, which I won't go into right now. But as long as I can do that, I can transfer the house to my adult child. So we call it the caregiver child exemption. There's another exception to gifting, and that is if I have a child that receives SSDI, Social Security Disability, okay, SSDI, I can transfer an unlimited amount of assets to that child and then apply for Medicaid the next day, and it's not considered a gift. Okay, SSDI. All right, so there's those two exceptions. There are situations where a spouse can, and I'll be very brief with this because I want to touch on the asset protection trust in it here is to kind of finish things. There are situations where there's something called spousal refusal, where a spouse can actually sort of refuse. So situations where, a couple keeps their assets separate, a spouse can refuse to have their assets be part of the equation when applying for Medicaid. And what would happen in those cases is that, let's say that my wife has assets in her name, I've got assets in my name, I end up applying for Medicaid, she goes the spousal refusal route, she refuses to divulge her assets, I can be approved for Medicaid just based on my assets alone. However, the state can then go after my wife after I'm approved and try to seek contribution from her. Okay, but now what the benefit of this, and I can say that I don't think we've ever done this for a client because there's a lot involved and it can get kind of messy, and there's just a lot of unknowns. But what can happen in these situations is, the state, if we pay the nursing home privately, it might be $10,000, but the state of Illinois, what they're paying the nursing home might be $5,000, $5,500. And so in a situation where my spouse refuses to pay or have her assets used, the benefit in some cases could be that down the road, when the state seeks reimbursement from her, they're going to have her repay the state the amount that they paid out. So now she's paying, $5,500 a month for all those months once they come to get the money from her versus the $10,000 a month that she would have paid. So again, in a lot of these cases, just kind of depends on the facts. Because another option we have in some of these cases is where somebody's applying for Medicaid. And here's the thing, again, I got 5 minutes. I want to get through this. There are couples that come to us and when they're way before this whole scenario of needing care, right? So there's couples that might come to us in their, when I say realistically, let's say 60s, like late 60s, early 70s, maybe even early 80s. And they're healthy. There's no reason to believe that they would have any kind of medical events that other than some sort of very sudden medical issue that arises. But they have no reason to believe that they would need any kind of care anytime soon, and they're concerned about a situation where one of them might need long-term care and going through a lot of their assets. And so they might come to us, and there is work we can do where we can create a certain type of trust, an irrevocable trust, and we can put the assets in there, okay, and we can protect the assets. But because of Medicaid's 5-year look-back period, we have to do that 5 years before we're applying for Medicaid. It doesn't have to be 5 years before we need some sort of care, okay? Because we might need care, those clients might need care 4 years down the road or 3.5 years down the road. Okay, well, they might just have to pay for that care out of pocket. But we can protect assets by putting them into an asset protection trust, an irrevocable trust, as long as it's more than 5 years before we apply for Medicaid, okay? Being conscious of that 5-year look back. Okay, so there's situations where people are more proactive, right? And they think about this and they're like, okay, I think this would be something that we should look at. And then there's situations where, people weren't proactive, and that's not a bad thing. Most people have no idea that that's even an option, that exists. And so what happens is, their loved one is in rehab. They have that meeting with the rehab facility, and now they're being told that, Medicare is going to stop paying in 5 days, and it's going to be $10,000 a month. And now they're freaking out because they're like, this is going to bankrupt us. And a lot of times it's the concern is when there's a spouse, the concern is, okay, this could significantly diminish what the spouse has to live on for the rest of their life, especially if they're much healthier, or they're much younger and healthier. I mean, all these different factors. So there's planning we can do at the last minute where we can help protect assets, and we can help protect assets typically in the range of about 50% of what the assets are above what Medicaid would allow that couple to keep. So if the couple, Medicaid, if it's a married couple, and Medicaid allows the spouse at home to have about 135,000, the individual going to the nursing home keeps 17,000 plus a house, plus a car. Sorry, I forgot to mention that the spouse can also have a car. Okay, 135,000, a house and a car. So yeah, we know that without doing anything at all, the couple can basically keep about $150,000, a house and a car. But if they've got another $300,000 on top of that, or $500,000 on top of that, that's at risk, there's plenty that can be done even at the last minute to help protect about 50% of that. And again, every situation is different. It kind of depends on the type of assets that are involved and sort of what's at play. And somebody's incapacitated. This is where powers of attorney become very important. Does their power of attorney have the right language in it that would allow the family to do this kind of planning? If it's just sort of like your standard power of attorney that you got from an estate planning attorney who doesn't really have any kind of focus on elder law, it probably does not have the language in it that would allow that type of planning to be done by an attorney like us or other firms that do the same work as us. So it's also very important to make sure that we take a look at those powers of attorney to make sure the language in there is broad enough to allow for this. But again, I just want to get the point across that it might turn out that there's nothing that can be done. But in a lot of these cases, it's worth looking into to see, is there something we can do? Is there something we can do to protect some assets here, even though it's the last minute, even though we didn't do this 5 years in advance? There's a lot in these scenarios. There's a lot going on. Families are extremely overwhelmed. Obviously, it's best to try to get some information on these things before the fact, but I also understand that that's just not realistic. I mean, most of us are going to be, way more reactive versus being proactive. And again, a lot of people just don't even know these things really exist or these things are out there. But good to have an idea that there are some options. And again, it might turn out that there's not a good answer in every single situation is also what I want to say. Just because I'm saying that in some of these cases, there might be the ability to do this or do that. There might be, but there also might not be. Okay, so I never want anybody to think that it's for sure that we can protect assets at the last minute no matter what. Not necessarily. We may not be able to, but it's probably worth sitting down with somebody to see if there is an option, if that situation does arise. So it's 10:15. I got a dry mouth. I can hang on for a couple minutes depending on unless there's another talk right after this and somebody needs the Zoom link, but I can stick around for 5 minutes is kind of what I can do if anybody has any questions. And I'll also put
5 minutes is-
I'll also put my contact information in the chat box for
Yeah.
anybody that might want it.
And I'll email it out too, in case we close this and they don't catch it in time. And we've got about 5 minutes on our end, so that's great.
Did you want us to raise our hands, or how did you want to handle quick questions?
Go ahead.
Just out of curiosity, did I understand you correct? It's that 17.5 doubles for couples?
I'm sorry, what was that?
That $17,500 is doubled when it's a married couple, or?
If it's a married couple and they're both in a nursing home on Medicaid?
No, meaning because they're going to look at both spouses' assets. So one spouse is in a nursing facility, skilled nursing facility. One spouse
So-
is at home on retired as well.
So the spouse at home can have $135,648.
Okay. So the 17.5 is just the bare
Yeah,
minimum.
the individual
assets.
that's in the nursing home applying for Medicaid, yeah.
Perfect. Okay. Okay. And any additional properties? Does it matter if there's equity in the property or not? Or what
Say
if
that
the
again.
what if the property is, owes more? Then, there's no equity in the property, but there are.
Well, so, yeah, so I mean, there's definitely situations where we've had clients. So we've had clients where, they had, an outstanding mortgage on the home, but they had $250,000 in the bank. And so what we've advised them to do is you can keep this because the spouse can have the house. Take that $120,000 you have that's extra in the bank that would otherwise have to be spent down at the nursing home, pay down the mortgage, and apply for Medicaid. No, so that's always an option. I had clients one time where they were renting an apartment, and I told the wife, and they had like 600,000 in the bank. I told the wife, I'm like, go buy a house. It might sound crazy, but she bought a house that she immediately protected $400,000. Medicaid at the time allowed her to keep about 110. So she spent about $70,000 at the nursing home, but saved a ton. And then she ended up selling the house down the road. So once in that type of situation, once the individual, and let's say that in her situation, once her husband was approved for Medicaid, once he was approved, she can sell the house. She can sell the house and have $800,000 in her name. She could win the lottery. Sounds crazy. But once that spouse is approved for Medicaid, the spouse that's living in the community, we say living in the community, meaning, out in public, not in the nursing home. Once that spouse living in the community, Medicaid will never ask about their financial situation ever again.
Lovely. Okay.
Every year, Medicaid will send out what's called a redetermination regarding the individual that's in the nursing home on Medicaid and just ask questions to see if their financial situation has changed, right? Were they the beneficiary, because people related to them might pass away and they might receive life insurance proceeds. They might be the beneficiary of somebody's trust or will that passed away. So they're always going to check in on that individual who's receiving Medicaid, that spouse. But as far as the spouse that's living at home, they're never going to check on their financial situation again after the approval.
Thank you.
Yeah, of course. Any other takers? Guess that's it.
All right. Aw, thank you, Matt. That was really informative and helpful, and I'm glad that people were on. And Matt's next talk is next month. I've got March 5th at 9:15. Please join us. He'll be talking about estate planning and answering questions, at the end answering questions, but telling us the ins and outs about that as well. So please, I'll send a link as well for that to register for it. So.
Perfect.
All right.
Thank
Thank you so much.
Amy, thank you. Everybody have a great day.
Bye.
Thank you.
Thank you.